We do want to begin today as we continue to keep a close eye and track the investigation into the death of a Titusville teenager who was found dead on board a cruise ship. We have talked a lot over the past few days and a couple of weeks since the death of Anna Kepner, who is 18 years old. Still a lot of questions surrounding what happened. The FBI has said very little about the investigation into her death, and what we have learned about that case, or most of it, has come from court filings in an unrelated case, a custody dispute in family law court in Brevard County that has shined a little bit of light on the case, on the suspect who's believed to be the 16-year-old stepbrother of Anna Kepner. And now there are some new court filings as well that talk a little bit more about this, including mentioning the fact that the FBI is investigating this as a, quote, suspected murder. This court document was just filed recently in Brevard County Family Law Division. Joining us live now to talk about this filing, kind of explain it to us, talk more about what it means and what it means for the investigation that the FBI is doing as well. I want to bring in Jose Rivas, who is a criminal defense attorney. And Jose, we always appreciate your perspective, and thanks for joining us this morning here on Fox 35 News Plus.
Good morning. Thank you for having me.
Okay, so you have had a chance now to look over this document, which, as I understand it, is Kepner's stepmother essentially asking for a gag order in this family court case.
Yes, this motion is about process and confidentiality. When we talk about family law court, we're talking about family. We're talking about the best interest of the children. And what they're asking the court is to, protect them, so to speak, right, or any other parties that are involved here, and say, listen, don't talk to anyone else. Don't reveal any kind of text messages, information, or whatnot. But again, it's family law court, and family law court doesn't tell criminal court what to do, and criminal court doesn't tell them family court what to do. And above all of that, it's federal court, which obviously supersedes any of those other courts.
So this the document that we're looking at today is wanting additional filings in the family court proceedings to be sealed. They want those family court proceedings closed to the press as well, and trying to get those associated with this family court case to stop talking about it. So what would a judge who would be considering this motion be looking at as to whether or not to allow that and approve that?
Well, judges are always very hesitant to restrict information. I mean, one of the elements on the motion is they're asking the media not be present, not reveal any other kind of documentation. We cannot use family law court to hinder a criminal investigation, especially a federal investigation by the FBI. So the judge is going to be very cautious. You want to protect the interest of the child, but to a certain extent, not to expose them, for them to incriminate. But it's really not the court's job to tell a person, hey, anything you say can and will be used against you. That's why they should retain private attorney, and the attorney would tell them that anything you say in this particular proceeding can be used against you. And then they have the right to remain silent. But the point is, you cannot use family law court as a tool to hinder a criminal investigation. And the judge is going to be very cautious as to what restrictions she actually places on this.
How is a family court, family law division case like this kind of different? Are the rules a little bit different between a criminal proceeding and a family law proceeding like this?
Well, absolutely, yes, they are, and they're each. But again, they don't get involved. Like the family law is not going to tell you. If the family law prohibits contact, and the criminal law court, you have an open criminal case, they allow contact. One does not override the other. Therefore, you have to go to both courts. So yes, and the main focus is, they're not really focused on the criminal aspect of it. They're focused on protecting the child. But there's a difference between protecting a child and hindering a criminal investigation. And there's and also limiting access to the media and information that otherwise would have been revealed. Just because there's a criminal investigation doesn't necessarily mean you have to put a gag order in and restrict the information that would usually be allowed for public access.
One of the quotes, I want to get it right here, from the court document says that one of the reasons they want the proceedings in this family court case closed to the press because they say, quote, in the event criminal charges are filed against the minor child, referring to the 16-year-old stepbrother who's the suspect in this case, his right to a fair trial may be tarnished. Do you think there's weight to that argument, or what do you think about this argument in this motion?
I don't think that's not an argument that should be done in family law court. That's an argument that should be addressed in criminal court, where a judge, that's the reason you have jury selection, and the judge will determine if there's an impartial jury. So it's not the family law court to pick or protect, so to speak, the public. I think that question has to be addressed in criminal court.
Right. What do you make of this? I want to dive in now just a little bit kind of bigger picture here as we continue to watch this investigation, and how little information has come out from this from official sources. I mean, these family court documents are kind of the only way that information about this criminal case has really come out to this point. Does that surprise you in a case like this, or no?
Well, what's interesting in this case is that it's the parties in the family law case who actually put out the statement in the motion, and that would grab, public attention. Had they not mentioned any of that, if you notice, there's no information really coming from the FBI. This is an FBI agency. They do the homework before they prosecute. They're very cautious as to what information they release. So they kind of asked for this. They went ahead and revealed this information. Now they're telling the court to say, hey, listen, let's keep it quiet. Let's keep it out of the public.
So what do you think, if you had to look at your crystal ball here and see what the judge in this family court case, looking at this motion, might do, what do you think we might see come out of this?
By the end of the day, there is a remedy, right? This is a family law case, deals with alimony, custody, and they have a right to stop. If I was a judge, I would tell the parties, if you don't want to disclose any kind of information now, you have to remember the reason we're in family court for family law issues. Therefore, you could postpone, it's mute, let it sit until the criminal investigation is resolved. But don't make me, the judge, tell other parties, and that not to change how the process of the family law court just because there's a criminal investigation going on.
Right, and that's interesting to see. I think some of these things come out in these other documents. The fact that it is a totally kind of separate division of the court, an unrelated case in many respects. And to see this, but at the same time, I think if you're talking about a custody dispute there, I guess the attorneys could and kind of are making the argument that some of this stuff is relevant to what they're talking about in the family court case.
Well, you can always come forward and make the argument, but I think they're overreaching, overstepping, and asking the family law court to do something that they don't have any authority or any jurisdiction to do so. And for that reason, I think the judge is going to be very, very cautious as to what restriction. And there is a remedy. The remedy is you can halt the family law procedure until this is resolved. Don't make me tell or make a decision to that could hinder a criminal investigation.
The fact that this is a minor, that the suspect here is a 16-year-old, and that's something that they kind of discuss in the this motion asking for the gag order. I'm curious what impact that might have when it comes to potential criminal charges moving forward. If that is something that we see, could this be a case where we see someone, despite being underage, potentially face charges as an adult?
Well, the reality is that there are certain crimes that regardless if they're a minor, they can reveal the name and the information of the minor. We've seen that in other cases where there's a juvenile 12, 13-year-old, and they've revealed the name and the identity. Now, the issue becomes is, do we want, this court, put those kind of restrictions, and where do we stop? The reality is that this juvenile is going to be assigned an attorney. He's going to have a prime attorney, the right to the attorney, and he has the right to remain silent, but we shouldn't be using this procedure to hinder an investigation. And after all, this is the FBI. I think one of the issues in the motion says we want the father not to give him any text messages. This is in the federal FBI investigation. There's no expectation of privacy. They have access to everything: text messages, phone calls, GPS for phones, regardless of whether this judge puts a gag order or not.
Interesting. A lot of things at play here, Jose. It seems like just a lot of different moving parts when it comes to a case like this.
It is, and again, I think they're overstepping on the authority. I think the FBI eventually is going to come out and, they're going to either whether they're going to charge or whether, and, you have to realize, sometimes the truth doesn't matter. What matters is what you can prove. And you'll see that in a lot of cases where the prosecution will come out and say, listen, we're not going to find the charges. We just don't have enough to move forward. And the FBI has a very high conviction rate in federal court. It's like up in the 90s. If they can't prove it beyond a reasonable doubt, most likely they're not going to move forward. And that's what they're doing right now, trying to build the case prior to having a formal arrest.
And what does these court documents that are kind of, I don't want to say leaking because it's, these are public documents and that's not the word, that the actual word I'm kind of looking for, but kind of dripping out some of this information from this potential criminal case and this criminal investigation. Does that, do you think, have an impact on a potential future criminal case, that some of these details have been dripping out bit by bit from this other case in the family law division?
Well, there's always suspicion, of what gets, quote unquote, dripped out there. But the reality is, if this person is charged and if he goes in front of a jury at some point, the judge is going to tell him disregard any other information. We see that all the time in high profile cases, that, they can only consider what's presented to the judge in the courtroom. And again, we have to remember, if he's charged or she's charged as an adult, if it stays in juvenile court, it's the judge who makes the final determination of guilt. There's no juries in juvenile court.
There's still a lot of questions, still a lot to wait to see. Jose Rivas, a criminal defense attorney, we always appreciate your perspective and your time, and thanks for sharing your expertise with us this morning here on Fox 35 News Plus and putting this stuff in context for us.
Thank you.